Warning: this episode contains discussions of sexual violence, trauma, and systemic injustice. Some content may be distressing or triggering, especially for survivors. Please listen with care and prioritize your well being. Support resources are listed in the episode description below.
I had a little chance to take a brief look at your bio. Of course, we love to do our research here at Revive. I think you're well known, and I was hoping that you would share a little bit about yourself and your work with our audience.
Yes, so I've worked in the criminal justice system since 2012. So it's been a few years. And I've been working in one way or another with survivors of various criminal cases because I work in the criminal justice system. So I've been able to see somewhat firsthand how navigating the court system can be.
Of course, it's going to revolve around intimate partner violence, domestic violence, sexual assaults, etc., and the ways in which law enforcement and the ways in which community agencies like Revive, YWCA can support victims, can support survivors, and basically can give some awareness to the community. If you can share with us any unique perspectives that you've gathered over that time, especially on the challenges that survivors might face navigating the justice system.
Yes, so working in the criminal justice system, you get to see, at least from my perspective, working in the legal field, you do get to see the court system can provide some disenchantment, I would say, to the victims, just because I know that one of the things that I think about is managing expectations. When a survivor comes into court, they don't know how the justice system works. And I feel like sometimes we should take the time to explain to them, not like all of the ins and outs, obviously, of the justice system, but for example, the burden of proof, which is beyond a reasonable doubt, which is the highest burden and the hardest burden. I think that's something that needs to be explained just to manage expectations when you come into court. Because it can be really difficult when you believe that you're coming into court, I'm telling my truth, and then this person will be held accountable. It's as simple as that. And there are nuances, and there are things that don't have anything to do with the survivor that weigh in the court's mind, and that may lead to an unfavorable decision. So that, I think, that would be what I see as a unique perspective, is just that they come in expecting something that they may not get, not because someone doesn't believe them, not because they're not telling the truth, but that's just the way the system is set out.
Advocacy in all areas is so powerful, and it's so important in addressing some of these gaps, Then I would ask, are there any other types of improvements that you can see that might work for survivors' access to justice? Having more training, obviously, is a big one, but is there something else maybe that you've noticed in your experience that would help survivors?
I think having more training, but also you spoke about collaboration. I do think that victim witness and the legal professionals need to work more closer together, I would say. We do run like parallel to one another until you get closer to like the matter being in court, then you kind of have to get more entwined. But I think we need to have a closer relationship, a more collaborative relationship to make it work, so that way when it's taking so long in the court system, at least they have a check-in person, for example, to be like, yes, we're at 6 months, but here's where it's at. We have, for myself, it's more of the legal professional will speak to the victim witness worker, who will speak to the victim, and then it's just kind of more relaying information, as opposed to us working together to be like, this is the issue, let's see what we can do. The survivor is feeling like they don't want to proceed. The survivor is feeling like nothing's going to happen with this case. What can we do? So we're being made aware of those feelings before it gets to the point where they just disengage.
Yeah.
So it's beneficial to both parties in that, the matter will go through the court system, and the survivor will be made aware, so they'll feel more comfortable with it. Yes, it's taking a long time, but I'm aware of what exactly is going on. I'm not just thinking I have no voice and nobody cares, because that's a sentiment that as a legal professional you see a lot, is that nobody cares, so then I don't care anymore. You guys don't care about it, so I don't care about it. They're getting away with it, so I don't care about it. I don't have time to put into this now because it's been this long and no one's ever spoken to me, or no one's keeping me updated, or just telling me that it's in the court system. And what does that mean? And what does that entail? And how long? While we may not be able to give an exact amount of time just because we don't know either. It gets set for a trial, and that trial is based on whatever schedule the court has. The legal professionals don't exactly know exact dates that are coming up, but I think that if we have a more collaborative relationship with victim witness, it will be beneficial both for the case going through the court and the survivor being engaged in the system, continuing on all the way to trial, and being able to have that person come in and be like, I'm ready to testify, as opposed to, I really don't want to be bothered with this anymore. Nobody seemed to care, so now I don't care either.
When someone does recant, and then let's say 2 months later, they happen to be living in a difficult and dangerous situation the entire time. So they recant, but 2 months later, they found themselves again in this position, and they feel like, I can't do this. I want to tell my story, and they come back to begin the process again. Number one, are they beginning the process again from scratch? And is there any, I think, without making assumptions, there is an assumption, there is an idea, or even a fear that this time around I may not be taken seriously because I did this and withdrew and now I'm back again. But is it starting the process from scratch with all due sort of like fairness, with, you know what I mean, without bias, and just moving forward as if, well, here's the complaint, we're taking it from the top? Yes?
You're taking it. So when somebody recants in the case and we decide we're not going forward with the case, and the case is withdrawn, they come back a few months later, that's a brand new case. So there's no asterisks. There's nothing being like, this person has this, here we go again. No, that's why it's a policy for the police. If they hear a domestic violence allegation, they must arrest. So they don't even have the ability to be like, well, here the victim survivor is again saying that they did this again. I don't think we're going to proceed. They don't have a choice. So they have to proceed. So even when you come in, you start off at the beginning, it's a fresh, clean slate. There are no choices for police. If you come to the police and say, I have been assaulted in whatever way by my partner, my husband, my wife, my boyfriend, my girlfriend, however you may call them, they have to proceed. We may get information when we're releasing all the disclosure saying that there was previous allegations, but we don't take that into consideration when we're making a decision on whether we proceed or not. We have to look at the case afresh and anew, leaving all of that out. What do we have to prove this case? That is what we're looking at. What is the evidence we have to prove this case? They said this happened, and we're aware that, okay, we have information that there was a previous allegation. What happened to that? Okay, didn't proceed. They didn't want to proceed. Okay, we move on forward. That just makes the legal professional know, I need to pay close attention. Right. I need to just check in and make sure that everybody's okay and we're still proceeding, and that because this person has changed their mind before, you just want to make sure that you're touching base, be like, is everything okay? Do they need a meeting with us? This is a long process in the court system. So you kind of just want to do a temperature check almost to be like, we just like to meet with you, explain the court process to them so they're aware. It does take a little bit of time in the court so they're aware, so that if there is feelings of, I don't know if I want to proceed, we know now, and we could start to try to mitigate that or change it back before it goes the other way.
I've asked something that I hope gives a little bit more hope to our audience, something that is more of a personal question for you in terms of the challenges that you see. You've seen so many, obviously, you work through so many, you are in close communication with survivors, with victims, with community agencies, community partners, all of it. what keeps you motivating to continue your own advocacy? And what do you see for the future? What are you hoping for the future? And again, what do you see that has maybe been working that you would like to see continued?
So the first question, what keeps me going, I think, is I have two girls. I'm a mother of two girls. So I think they keep me going because I want them to live in a society in which, if this thing would happen to them, which obviously I don't want to, but if it does, that we have a justice system that works for them, and we have people in the system that will do all they can to help them navigate the system, whether it be police officers, whether it be victim witness, whether it be legal professionals. They have that to help them. I want them to be able to have a justice system that works for the victims. And it's sometimes hard in a justice system to be that victim advocate, but that is what legal professionals, at least on my end, we work for the community. We work for the community that is there. So the victims and survivors, we are trying our best to present the best evidence to the court to show that what they have said happened, we can prove beyond a reasonable doubt. So I think my children help me to do that, and also just my belief in the justice system being something that can work. As you can see, I'm a person of color, I'm Black. So the justice system was not made for us historically. And so working within it, I'm trying to work the system so that it can work for us. It can work to be quote unquote blind as they say it is, but it so rarely isn't. So my job is to work within the system to ensure that there is a voice being heard, and there is my unique perspective as a Black woman in Canada, who has grown up and lived her whole life in Canada, giving that unique perspective as a legal professional. It does color what I do, color my perspective, color my opinions, but that's a good thing. It's a good thing to have my opinion. It's a good thing to have my point of view, in my opinion. It's a good thing to have diverse points of views and opinions as legal professionals so that we're not all saying the same thing or doing the same thing. We need to be able to see that. So I think knowing what I bring to the table also is a way that helps me to keep going, that helps me to keep being an advocate, knowing that I bring a unique perspective to the table and that it's a voice that is not heard very often in the legal profession that I work in, but needs to be.
So thank you so much for joining us today. We really appreciate you taking the time to share your insights, your knowledge, your expertise with us. And so we're kind of looking for your perspective in criminal defense and your dedication to social justice. We really want to get into a good sort of informational conversation today. So to start off, I'd love it if you could tell us a little bit about yourself and your background and what drew you to working in this field.
Sure. So I've been practicing criminal defense work for over a decade. My background before I went to law school, I have a degree in history and gender studies. And after my undergrad, I worked in what used to be called the violence against women sector, the gender-based violence sector now. I did some frontline work, rape crisis centers. I worked in the downtown east side of Vancouver with street-involved women and some nonprofit and board governance work as well in that field. So always been very passionate about the work. Then I went to law school, and since being called to the bar, I've practiced in criminal defense. I used to work for legal aid, so I've always worked with vulnerable people. But I've run my own practice for about 8 years, and I would say half of my practice for the past few years has been complainants or survivors. So complainants is, I would say, the term in legalese for a victim. So we use the word complainant before someone is convicted, and then after they're convicted, we would use the word victim. So I do a lot of that work, advocating for women and other people who are complainants or witnesses, and then I also represent accused persons as well, many of whom are women too. And we know that, I think that this idea of victim and accused, of course, it exists, and there's various power dynamics, especially in terms of gender and race and class, that we need to acknowledge. But I think for the experience of women and gender diverse people in the criminal justice system, the binary of victim and accused doesn't really like apply in the same way. So many of the women that I work with are survivors of trauma. They have been victimized, and they go on to become, unfortunately, involved in the criminal justice system, because I'm of the view that the criminal justice system is a bit of a catch-all. It's, for many of these women, it's the end of the road in a social safety net that has like utterly failed them. So when they arrive in the criminal justice system, they often have intersecting legal needs, immigration, refugee needs, family law needs, social assistance. So their legal needs are very complex.
So can I ask then, from your experience, what do you believe are the most significant legal barriers for survivors of sexual violence? And I believe you work with victims of trafficking as well when you're navigating the justice system.
So legal barriers, I would say the biggest legal barrier is just like right to counsel. So there's a real access to justice issue. So the province of Ontario rolled out an independent legal advice program. I believe it's either, I think, 2 hours to begin with, and then the survivor can apply for a second 2 hours. And that's currently went through a process of some community-based research, and that's now, as I understand it, being overseen and run by the Barbara Schleifer Clinic. So that's a means in which folks who are aware of that service can get legal advice. But putting that aside, there are no really very little to no legal advice, free legal advice for survivors. And that government program that I mentioned through the Schleifer Clinic, as I understand it, is only for survivors of sexual violence. So when we talk about gender-based violence, we're of course talking about domestic violence as well. So those women and other folks are left out of that. So it's a really big gap, because I do a lot of court appointments for sexual assault applications. So there's various sexual assault applications where a survivor will get a court-funded lawyer, basically involving applications to bring records into play in a trial, or for prior sexual history, or perhaps text messages in the accused possession. And it's so frustrating, because so often we get the client's statement, the complainant's statement, because it's obviously relevant to giving them advice. And it's very challenging, because it's oftentimes, if only they had the opportunity to speak to a lawyer before, like this would have been a real game changer. Because what we're up against, of course, and I'm sure you're aware, is just the criminal justice system, and the trial process is just such a crude measure. It's such a crude way of dealing with trauma. The court is concerned about reliability, which is, I guess, the quality of the memory, ability to recount details, dates, and consistency, which is like truthfulness, or if someone has a motive to lie. So these issues can arise, and police officers don't give legal advice, and the way that they do their interviews for these cases is basically they're encouraged to let the survivor just kind of speak, and then they'll ask some follow-up questions. So it's a very unstructured interview. And these issues can arise down the line, and they can just blow up a case and result in getting charges withdrawn, which is fine if that's what the survivor wants, but it's often not. And so I would say that that's the biggest legal hurdle is a failure to provide meaningful and free, accessible legal advice to any woman or survivor who's making a complaint to police before she makes a complaint to police.
Okay, so then I would ask, as a legal representative, even as a community advocate, what can we do to sort of advocate and push for system changes that would improve and would reduce these types of gaps, that would allow survivors to feel a little less pressure to be reliable, as you would say, because it is a traumatic experience and all the details are not always fresh and they can be hard to recount. It can be difficult to just speak about something that you in your mind may have vivid memory, but to put it into words, to express it can be really difficult. So what can we do as community members, as legal representatives to advocate, maybe change policy, create new policies so that there aren't these large gaps in the system?
Right. Such a big question. I think funding for in-house like legal counsel or frontline legal workers, they don't even necessarily need to be lawyers. They could be paralegals to provide more advice to women before they give statements to police. We also need funding for more advocacy throughout the process. It's not only at the police interview stage. So, a criminal matter is just between the accused and the Crown Attorney who represents the government. Yes, a Crown Attorney is supposed to act as a minister of justice. That's their obligation, but they do not represent victims. They're obligated to take victim input into account. That comes from the Victims' Bill of Rights, but they're not obligated to follow it to a T. And the Victim Witness Assistance Program, although I think they're very well-meaning, survivors often don't feel that they're meaningfully providing their input to the Crown. So there's also a need for advocates for these women throughout the process. And what happens is, because those positions are few and far between in terms of free services, women and other survivors who can afford representation can hire a lawyer, but most cannot. So it's also an access to justice issue. So I think women's organizations can apply for funding for those types of positions. I think that would be very meaningful. But the broader issues are so systemic and actually deal with like what is the very utility of the criminal justice system at all. It's a carceral system. For some survivors, they want a carceral response, and that's fine. They ought to be entitled to that, but many survivors go through the court system and don't find it meaningful. They might find it very traumatizing. And I don't realistically think that we're going to abolish the criminal justice system. I think what might be a more realistic goal is to really work on lobbying the Ministry of the Attorney General to consider implementing a model of restorative or transformative justice alongside the criminal justice system that would be appropriate for certain gender-based violence cases where the survivor wants it. But there's so many of these cases, that sexual assaults and DV, that arise in the context of people who are known to each other. And often survivors want restorative or transformative justice, and the Crown won't allow it. So I think that that's very problematic. So I think there's a role for community justice organizations to also lobby for alternative methods of conflict resolution as well.
Serious offenses versus not. How would someone know what situation they're in? Sometimes a person may feel like, that this isn't something that I would report. This is something that might happen all the time. They may even be told, that's not a thing. So how can a person understand how serious it is, whether or not they really want to move forward? Again, what to expect, but mostly understanding what may be considered serious, because sort of any type of assault or violation of personal space and body feels serious, I would say. But I understand that when you're possibly thinking it through, thinking of, maybe somebody won't believe me, depending on what situation you're in, you might have somebody that you share this information with, and they might be like, those charges would never go through. That's not a real thing. You're going to go through all of this for no reason. Is there a way that, based on your experience, based on your knowledge, that you could kind of give advice or to someone to say, this is something that would be considered a more serious offense versus not?
Sure. So I'd like to just put the definition of serious offenses as I said it, referred to it before, aside, because I think that's a legal definition. And it's not really relevant to, as you said, to someone's lived experience. So in terms of the process of reporting a potential crime. So first of all, after, decades of neglect of, I would say, sexual violence and domestic violence, it's one of police's like number one priorities, that and firearm stuff, and obviously like serious violent crime. And I say that I'm talking about things like murder, attempted murder, aggravated assault. So police take gender-based violence and domestic violence very seriously, I think. They've been trained to do so. And so they ought to be taking a report in any instance where there's a suspicion of domestic violence. And what they'll do if they determine it doesn't rise to reasonable and probable grounds that a criminal offense was made out, and we'll talk about what those offenses will be in a moment, they'll make a report, and that's called an occurrence report, and that stays on file, and it is a relevant record. Could be relevant in family law proceedings, it could be relevant down the road in criminal proceedings, in a bail hearing, it can be relevant. So I would encourage anyone who has fear for their safety to make a report, for sure. Because the truth is, in the majority of cases, if you make a report and you down the line change your view and you don't want to participate, the Crown really should be listening to you. Can I guarantee that that will happen all the time? No, absolutely not. There's charges that the Crown will proceed on with or without your input, and it can depend on not just on your community, obviously, but the seriousness of the offense. And that's, again, referring to the legal meaning, which would be, well, what are the injuries? Is it a penetrative rape? These types of things. So the most typical offenses that I think would speak to the domestic violence scenario that you're alluding to potentially. So obviously there's sexual assault. Let's just briefly address that. So the offense of rape no longer exists in the criminal code, which I personally think is problematic, and many feminist scholars do as well, because what that means is there's this offense of sexual assault. So we'll hear in the media that someone is charged with sexual assault, but we don't know what that means, right? So sexual assault is really broad. It's any touching for a sexual purpose. So it could be, again, quick over the clothes, full gamut, to penetrative rape, aggravated sexual assault. That's a sexual assault with injuries anywhere on the body, sexual assault with a weapon, etc. So there's that. And then in the DV context, assault. So assault is any non-consensual physical touch. It can also potentially include making a gesture if there's no physical touch. So if I were to, wave my hand very close to someone, it's possible that that could, be construed as an assault. Would the police lay charges in that instance? Probably not. But the police also have, other options. They can, import a caution. Sometimes the presence of police can be helpful. Sometimes the presence of police is aggravating. So individual would need to, make that assessment based on being an expert in their own lives. There's also the offense of utter threats. So just as it sounds, if you're making a threat to cause bodily harm to someone, or for a threat of death, that's a criminal offense. And finally, criminal harassment, I think, is relevant. So it could be stalking, watching, unwanted repeated communication. A reasonable person would have fear from the repeated communication, then it ought to be reported. And often at the beginning of harassment cases, a caution will be put out. And then if it continues, you have that, paper trail there to assist you. So my advice would be to seek legal advice, support where possible, but I would never encourage someone not to report. If they want to report, they should, and the police ought to be taking it seriously.